Here is a lordship, my lord. Rectum item 16, my lord.
16.
Uh, has possibly been misplaced.
2018. Okay. When?
Any date, my lord, after the vacation, my lord.
After Bihu vacation. Previous date after Bihu vacation. Or on a date to be fixed by registry. In the month, 3rd week of January, on a date to be fixed by registry.
May I be allowed to take certified copy of the petition?
You can take.
In a
Ah.
Obliged, my lord.
Petitioner, if that you apply, they will give.
I'll
If
apply.
Lordship, I beg to mention item number 10, Lordship.
item number,
10, Lordship.
yes,
And the agenda matter for a day, Lordship.
for a day.
Lordship.
I am for the petitioner, Your Lordship. After the
This
vacation.
is for NCB. When? After? After vacation. Okay.
January 1st week, any day.
Okay. The prayers, joint prayers of the Learned Council for the parties, matters then adjourn and be listed in the first week of
Any date you-
first.
Date may be
Give a date. 8th of January.
obliged.
Obliged, Lordship.
The Learned Council for the petitioner submits the chair's instruction to withdraw this matter. Accordingly, bail petition stays closed on withdrawal.
The item is, my lord. CD is there, man.
Which item?
The CD is not available, my lord, in this case. No, not in this case, but other items, my lord.
When it is fixed?
Today only, man. Today also one another item, my lord, item number 26, but
Hmm.
case there is not available.
How many bail petitions are there today?
Today, my lord, two motion matters, my lord.
Motion, one motion is, this is your matter, Mr. Das?
Yes, yes.
DA.
Yes. One supplementary.
Along with which matter?
Along with, my lord.
There are 3 bail hearings.
Yes,
Which one?
fix. My lord, this one,
Shahjahan,
Joybor Ali.
Joybor Ali.
Yes.
It's meaning there is Shahjahan, Joybor both.
Yes.
So all these matters, any CD in these cases, whatever?
Yes, my lord. Asan. Yes, my lord.
Okay, we'll see.
CD available.
And what about 11?
11, my lord, also case diary available, my lord.
Oh, 11 is something different.
Yes, my lord. Already during.
Huh? Okay, let us go by serial item number. Let us take item 10, 12, and 13. No, 10 is gone. What is your matter? 9, 12, and 13, is not it?
Yes, my lord, my case is arising out of, my lord, South Salman PS case 163.
Give the file. You are saying that this item number 9, 12, and 13 are common.
Yes.
9 and
12, 13, and 26.
12, 12, 13, and 26. Okay, who is for 26? You are in 26. Out of the same common affair.
Yes.
Please let us see item number 9. Where is the affair?
9, my lord, FIR is at page number 16.
Now, before proceeding further, translated copy. Okay, who are the accused?
My lord, accused are Azima, Zorib.
In item number 9, who is accused?
9, my lord, accused not named in the FIR.
So item 9 not named.
Not named.
Then who is item 11? Accused item
11, no, 12.
no 12 and 13. 12, what is your name? Not named. Huh? Just a minute. 11, this item 9 not named. Item 11 not named. Item 12 not named. And whatever item 13?
13, my name is
Huh?
name
Item 13, my name in the affair, serial number 3rd, 4th, and 5th.
3, 4, 5.
3, 4, 5. 3, 4, 5. And what about 26?
The 26, Lordship, after filing the AB,
Hmm.
the accused number 3 has been arrested, Lordship.
3.
Three.
3, that is Joybor.
That is
BA.
Item number 26.
Joybor BA. Okay. Now let us see what is the allegation.
There is also a counter affair.
Let us first go to the main
Yes.
effort.
Yes, 29/8/2024 at around 10 p.m. The aforesaid accused persons invited my young brother Kader Ali to their house from the street, and thereafter, without asking anything, the said accused person assaulted my brother with stick, rod, and sharp weapons with the intention of killing him, thereby causing severe injuries. So the accused person receives head injuries, caused head injuries by hitting my brother Kader Ali with sharp weapon, resulting in fracture of it and left leg. At present, my brother is undergoing treatment at Solis Hospital. So that is the allegation, madam. And our counter affair Azima, which was lost by Azima's mother, it says that, my lord.
Where is that?
That, my lord, is at page number 11. Here, my lord, the allegation was that, my lord, this Kadir Ali attempted to commit rape upon Azima, and that is why local public they caught hold of this Kadir, and thereafter, my lord, some altercation took place.
Okay. What the CD says? Who are the involved in this beating up?
Firstly, I want to state here, Lordship, the injury report is there.
Uh.
It is grievous.
That we have seen.
that-
But any implications of these persons?
Lordship, in the victim statement,
Mm.
moreover, I have also talked to the IO.
Mm.
He has stated that he is he is not released from hospital,
Mm.
but he cannot walk, Lordship. It is, he cannot walk.
Can you show against this man?
Shahjahan, his name is there,
Shahjahan,
Lordship.
son of
Name
Ibrahim
is there.
Ibrahim Ali.
Dr. Shahjahan Lakha আছে।
This is statement of
Victim,
the
victim.
victim. Just take it down. Jorif Ali. Jorif. Shahjahan Ali, son of Ibrahim Ali. Shahjahan Ali, son of Jorif Ali. Sobur Ali. Joybor Ali. Jobed Ali. What are the names? Just a minute. Cause list, cause list. Cause list. Why this matter is listed before this court?
Earlier allowed for one accused. madam.
Who is that?
Lordship, accused number 1 and 2.
What is their name?
Azima and
Azima and Zorib Ali.
Azima and Jorif. Jorif is not name. Jorif's son is name. Azima's allegation against that she called him.
Nothing is
So
there.
that's why we have granted both of
Okay.
this
Mm.
bail. Now let us see your names. Item number 9. Shahjahan Ali, son of
Ibrahim.
Ibrahim Ali, rejected.
55 days. madam.
Inside. This is BA.
Yeah.
Oh. Let him go. BA. BA, let him go to the satisfaction, considering the period of detention.
Second.
To the satisfaction of
CGM, my lord, South Salmar Mankas.
CGM Salmara Mankazar. Conditions all and all. Okay, 9 is
I-
gone. Then who is 12? Shahjahan. This is son of Zorif. Anticipatory.
Yes, madam.
Rejected. Anything to add? Specifically name how you have beaten him up. He is in hospital. Medical report is there.
Petitioner stated that he was not present at the place of, at
Maybe,
the time of.
maybe
place of
some
incident.
specifically name how and your role, how you have beaten him up. This case will not go. Take all this defense in the track.
Shahjahan,
Yes.
son of the.
Son of Zorif.
Yes, son.
Negotiation.
Perus the case diary from the FIR kind of likhibo, huh? This is the allegation. Peruse the case diary. The victims, after perusal of the victim statement, it is seen that that if Shahjahan Ali's son of Zorif Ali's role in beating up has been specifically stated by the accused. Full stop. The injuries are grievous in nature with fracture in leg. Therefore, considering the material available on record, this court is of the view that this is not a fit case to grant privilege of pre-arrest bail. Accordingly, steps. Come back after some time. Shahjahan gone. Then Joybor Ali.
Gobar and two others.
Joybor and two others. Who are they? Give the name. Joybor and?
Gobar, question number 3, 4 and 5.
No, give the name. I will compare. Joybor and?
Gobar,
Hmm.
Jobed Ali,
Jobed.
and Sobur Ali. Gobar is inside the jail, Lordship. Today is 66 days. Item number 26.
They will come later on. Will come later on. This application is under Swencho under 438. During the pendency of this application, petitioner number
Petitioner number 3, Lordship.
3, Joybor Ali, has already been arrested. Keep it there only. Peruse the case diary. Also, peruse the statement of the victim. Who are the others?
Others, Lordship, Jobed Ali,
Just a minute. Jobed and
Sobur Ali.
Sobur Ali. The victim, victim has specifically named. Your name is Jobed. Jobed Ali. And stated that this Jobed Ali and who is the other?
Sobur Ali.
Jobed Ali and Sobur Ali along with Shahjahan Ali confined him inside a room and beaten him up with lathi. Also peruse the medical report which suggests injuries grievous in nature, including fracture in the leg, and it is stated by the PP, additional public prosecutor, on instruction from the IO that the petitioner, a victim, is still
Not able
under treatment.
No, Lordship, he's out of the, but he unable
okay.
to walk.
Okay, not necessary. Okay, no, it is information necessary. Accordingly, rejected. Now come to item number 26.
Lordship.
Sobur Ali, same, that allowed bail application. How many days
66 days.
allowed?
I'm obliged, Lordship.
AB stands rejected, huh? And BA both are allowed. Yes, that is written, huh? Same, South China. Give your names in each cases.
Yes, sir.
Huh? Give a new name in your slip. Yes, that is written. Yes, Mr. Doctor.
Kindly pass over the matter for timing.
Okay. Yes, Padgiri.
I contact the accused number 1, madam. over the telephone as well as by letter, but he has not contacted that malad. He has not provided any copy malad regarding that service and that maintenance malad. Last malad, 1 week malad.
Okay, on the prayer of Mr. Padgiri, learned counsel for the petitioner, matter stands adjourned and be listed on January 1st week.
Let me
Give a date. Whether he is alive, nobody knows. 7th. You have some contacts in 7th. 7th to complete his instruction.
oblige.
What is the list? Michael, if we got more. Yes, Mr. Agar.
I have several points, but my lord, I'll confine to basically 2 points first.
Mm.
13.2, my lord.
This is against
My lord, conviction in the food adulteration.
why two revision?
Food revision, my lord, the
By
chemist,
2%.
or 2 persons, different person, my lord. He was a chemist, my lord. He was also convicted. He filed later on, my lord, separate.
One is Nestor Nutrition's
Nestor
Private
Nutrition
Limited.
is the company, my lord.
Ah,
Then 3 persons along with that, my lord, we have already filed four of the petitioners are there in that.
Hmm.
And another petitioner, he was a chemist, my lord. He filed a separate application.
where is that?
That is there.
So how many total file two
Two petitions.
petitions, both are here.
The first is, my lord, your lordship will kindly take the second one, my lord.
That is Nolin Chandra Das.
Nalin Chandra Das is the chemist, my lord. Your
Okay,
lordship
so
will
I'll
kindly
take up the company matters, Nestor Nutritions.
Lord, may I just pinpoint to my lord, that
Summary, what is the issue? How
issue is,
we
my lord,
Mr. Datta, it will take some time. To come back to you, it will take some time. So today or tomorrow or any day?
Tomorrow.
As per your tomorrow.
basic facts are there, my lord, that but we are having a factory. But my lord, the ice cream is, my lord, the manufacturer.
Mm.
Or produced. Now, my lord, on 27/8/1996, my lord, the food inspector,
Mm.
my lord, came to the factory premises.
Mm.
And my lord, he wanted to, my lord, visit inspect the factory and all that, and then ultimately, my lord, from the cold room, he, my lord, took the sample of, my lord, ice cream.
Mm.
And they have said that and it was Mr. Nalin Chandra Das who was there as a chemist at that point of time. He was not the director, not the manager, not. He was a chemist. That is a fact that has been established. Now, my lord, after that, another number 3 was also there. But she was one of the director looking after the other matters. Now, since they came, then she told that the chemist, Nalin Chandra Das, that kindly you, whatever they want to inspect and all that, let them inspect. And if they want to take sample, let them take. Sample was taken. It was sent for analysis. And it was found to be, not conforming to the standard. But I'm not saying adulterated in the sense, that some percentage of solid fats and other things were not found to be conforming to the yeah. Then after taking the sample, they have done their formalities and all that, and thereafter the prosecution was launched. Prosecution was launched, on 10/7/1996. The analysis report was given. My lord will kindly take note of that.
10/6.
10/7, my lord. Something wrong, I think, my lord. I'll just let me check. 8. I'll check and I'll report to. Let photo. Let just. I'm sorry, my lord. 6/6/1996, my lord, they have taken. I'm sorry, my lord. 6/6/1996.
6/6/96, they have taken the sample, inspected.
Inspected and taken the sample.
6/6/96.
I'm sorry, my lord.
10/7 is the analyst report.
10/7, they have sent it for analysis, my lord. 27/8/1996, report was received.
20,
7/8. Exhibit 22.
exhibit 22. Okay.
Then thereafter, they filed the offense report, my lord.
Hmm.
And after filing the offense report, they said that they have issued the, my lord, the copy of the report
Hmm.
were sent to us
Hmm.
by registered post on within the period of 10 days from the date of, my lord, filing the
Yes.
Now, my lord, thereafter,
Hmm.
2 witnesses were examined. On the basis of that, our statement was recorded, and my lord, we gave the defense statement of one of the director. Then ultimately, my lord, the argument was heard, judgment was delivered. The judgment was delivered on, my lord, 21/7/2023 by the Chief Judicial Magistrate.
Hmm.
My lord, convicting the company under section 7, it will be section 16 of the Prevention of Corruption.
Under section
7
of.
of Prevention of Corruption Act. So I'm sorry, Prevention of Food Adulteration.
Ah.
I'm sorry.
And others,
And 16. 7 read with 16, my lord.
7 and 16.
The company and all were convicted under that, my lord. So far the company is concerned, 1,000 rupees was fine was imposed. So far the others are concerned, my lord, 6 months imprisonment and fine of 1,000. And in default, rigorous imprisonment for 3 months. Then we filed an appeal. In the appeal was dismissed, affirming the judgment of the trial court.
Yes.
Now,
Fundamentally, what will be your
my lord,
grounds?
basically, my lord, I'll be urging on 13(2), my lord, section 13(2). Because if I go through the whole hog, my lord, it will take a lot of time. If need be, my lord, I can place before your lordships.
Your basic ground is?
My lord, the section 13(2) has been interpreted by the apex court, my lord. 67, and thereafter in the mid-time, my lord, there was a full bench decision of our High Court. It is not mandatory on all that. Then ultimately, my lord, in 2004, Supreme Court in State of Orissa versus Goranga has held that this is mandatory.
That you have to give the notice copy,
Not only notice, my lord. Sending of notice is not, my
not
lord,
their
only.
copy, so that he can use.
My lord, it will be served to him, my lord. That has to be, they have to give an evidence to the effect that it has been served to the person concerned, not only sending the, my lord, section 27 of the General Procedure Act, my lord, they deemed to have been served will not come into play. It says that they have to give an evidence to that effect, that they have not only sent it as required under the law, but it must be
Because it is a valuable right, so that he can raise an objection to the
so
analyst
that
report.
I can file an application before the, you know, trial court.
To have a tested
Send it to the Central Food
Central
Laboratory.
Food.
Director Central Food Laboratory, and if that, you know, the report is in my favor, or even if not in my favor, it will supersede the, my lord, report of the public analyst. That is the law, my lord. And in my humble submission, in this particular case, that has not been done.
So if that point clicks in this case, we need not go to any further. So therefore, we'll just go through who is the witness through whom,
I'll give them.
who is the witness through whom this proposition was brought in, that section 13 was complied with. Then we'll see the law, what is the manner and method to comply with section 13. If that is not there, then we'll see. Is that it, Mr. Bhattacharya?
Yes.
Instead of going detail reading everything.
My lord, of evidence and my lord, the exhibit has been prepared. Some of the exhibits are not available on the record also, my lord. I'll be.
No, basically, see through whom they wanted to say that this
No, I'll come to the evidence, my lord.
that part is required for a time being,
Yes,
not on how
not-
they
not-
seized, how they collected. Let us forget for a time being.
May I take to my lord the deposition volume. My lord will kindly take the page 1, my lord. May I read? No, I'm not reading the entire.
Not
My lord, your lordship will kindly directly come to page 5, my lord.
Hmm.
My lord will after the 7th line, my lord,
the page 5.
page 5. পদক্ষক 21 বছৰৰ অভিযোগ পত্ৰ
Project, sir.
21/1/21 লৈ মোৰ চহী এই অভিযোগ দিয়াৰ পাছত লোকেল হেল্থ অথৰিটিয়ে পদকীয়া গণনালৈ PF এক্টৰ সেকশন 13(2) অনুযায়ী নোটিছ পাব্লিক এনালিষ্টৰ প্ৰতিবেদন নকল সহ ৰেজিষ্টাৰ ডাগে যোগে পঠায় উক্ত নোটিছৰ কপি 22/1/2 RC বৰ্মাৰ চহী চিনু পদক্ষক 23 পৰা 28 লৈ ডাকঘৰৰ ৰচিদ Seven except saying that much. Lord, nothing has been said. Whether it was served on him or not served on him, Lord, nothing has been said. Now, my Lord, may I just pinpoint to one aspect of the matter, my Lord, there was no cross-examination from our side also.
Yes, that is.
Yes. It is my duty to point out to my.
You have also not raised that we did not receive it.
Huh?
You have, this is not your
No, my
defense.
Lord, but we gave the defense evidence. We have not received it.
Yeah,
613,
but there is
613
no
said-
suggestion in,
Oh, here, my Lord.
there is no suggestion.
No, my Lord. True. That's true. Because that's what.
You have not laid the foundation of your defense in the
That is true,
cross.
but still then, my lord, the Supreme Court in the latest decision of 2020 says that whether I have laid or not laid, it says that when
If you have a fundamental defense, of course, we cannot ignore only for this
and
reason.
in one of the Supreme Court says that it can be taken off later on also, my lord, this plea. I'll give the decision, my lord, if necessary. So, my lord, I have read yesterday also to find out whether we have made any
Raised-
cross-examination, my lord. I have not found it, my lord, subject to correction. Now, PW2 is, my lord, not important because he is not a person who has said notice and all that, my lord, so I'm not reading that. Now, if your lordship kindly come to 313, page 10, my lord.
Yes,
Of Nalin Chandra Das.
Hmm.
হয় আমাক লগ পাইছে মই কেমিষ্ট হিচাপে ইজ নট ৰিকুৱাৰ্ড your lordship can leave all
Anything in 313 as regards notice that so and so said
my
that.
lord, your lordship will kindly see question number question number 13 page 13 my lord. আপোনাৰ সন্মুখত লোৱা সেই চেম্পুলৰ সাক্ষীয়ে নিজে কাৰ্যালয়ত আনি তাতে এটা চেম্পুল পাব্লিক নেচাৰে পৰীক্ষাৰ বাবে পঠায় আৰু সেই নমুনা পৰীক্ষা কৰি চৌধক প্ৰতিবেদন দিয়ে চেম্পল অফ আইচক্ৰীম ডাজ নট কনফাৰ্ম টু ষ্টেণ্ডাৰ্ড মই সেই প্ৰতিবেদন এটা কপি আপোনালৈ পঠায় 22 যোগে কি ক'ব ৰিপৰ্ট আমি পাইছিলো I'll come to that. There is a defense evidence. Report was received after 2 years. আমাৰ final testing হোৱা নাছিলে then rest are not, my lord.
Not necessary.
Not necessary. On that particular point, your lordship, page 14.
Just a minute.
Important, my lord.
Page 14.
14. He will not, subsequently he says, my lord. আৰু কিবা ক'বলগীয়া সাক্ষী দিব নেকি? Your lordship got it. মই তেতিয়া প্ৰবেশন পিৰিয়ডত আছিলো ইমান তাৰিখে মই জইন কৰিছিলো ছমাহৰ বাবে পাব্লিক লাইসেন্স ৰিটেন কপি মোৰ নামত পোৱা নাছিল অফিসত পোৱা বুলি মই গম পাইছিলো
So according to you, even if it is served upon this person, he is nobody. to get,
He is a chemist, my lord.
it is to be to the company or its director.
No, company and other directors and other, who is the person responsible for
Even
this,
for-
my lord? No. But still then, my lord, he has said that he has not received it. He says that the company of Puaboli,
That I have learned.
I have learned. That's why, my lord, if your lordship reads question number 13,
Hmm.
and my lord, this question number 18. So
Together,
his answer
jointly.
is that he has not received it. Now, if your lordship kindly come to next page 15.
Hmm.
Hmm,
This is managing director.
Yes, yes. Page 15, my lord.
Hmm.
The same question is that উক্ত ফেক্টৰীৰ সিদিনা দ্বাৰা পৰীক্ষা কৰাটো সেইটো ভেজাল ৰিপৰ্টটো আৰু তাৰ কপি আপোনালোকে প্ৰেৰণ কৰিছে কি ক'ব? এই বিষয়ে মই পাছত গম পাইছো। নটিচ কপি পাইছো প্ৰায় 4 বছৰ মান পাছত। অফিচ ফাইলত নোট কৰা আছে। And he gave the evidence, my lord, as DW1. Next,
Very cool.
my lord, your lordship will kindly come to next, Bina Kashyap, page 18.
Hmm.
My lord, she died, my lord. I'll give the certificate for this, my lord. Bina Kashyap already died. In the meantime, but I'll just pinpoint to. Question number 7 at page 19, my lord. প্রশ্ন সাক্ষী 1 নম্বৰ 2 নম্বৰ কয় যে আপোনালোকে ফ্যাক্টৰীৰ পৰা স্যাম্পল আইসক্ৰীমৰ পাব্লিক এন্সাৰ ভেজাল বুলি তথ্য প্ৰতিবেদন দিছে তাৰ কপি আপোনালোকে পঠাইছে কি ক'ব? মই একো এনেকে কাগজ পোৱা নাই আৰু এনে ৰিপৰ্টৰ কথা নাজানো।
Hmm.
Then next is Utpal Goswami. Then your lordship will kindly directly come to page 21. Same question. ৰিপৰ্ট দিছে আৰু কি ক'ব তাৰ আপোনালোকে পঠাইছিলে? হয়, জানিব পাৰিছো। নটিচ কপি আমি পাইছো 2000 চনতে। Now, Niren Borua, he died, my lord. His answer your lordship will find page 23. Last question to answer. এই বিষয়ে গম পাইছো পাব্লিক এনার্জি রিপোর্ট কপি আমি পাছত পাইছো ভালদৰে মনত নাই কেতিয়া পালো। He has not been convicted. He expired during the pendency of this crime. Now, two PWs has been examined. One is DW1 Anil Chandra Das.
That is the exam. That is
Page 25.
that is the man who chemist.
Chemist. He's basically his evidence is that he was a chemist and all that on that. My lord, will kindly see turn to page 28, the evidence of DW2. My lord, your lordship will kindly directly come line about 6. যোৱা মে 1998 চনত মেনেজিং ডাইৰেক্টৰ আছিলো। মই 15/5/98 তাত লোকেল হেলথ অথৰিটিৰ পৰা এখন চিঠি পাইছিলো। য'ত তেওঁলোকে 30 দিনৰ ভিতৰত আমাৰ পৰা লোৱা আইচক্ৰীমৰ চেম্পাৰটো ইচ্ছা কৰিলে চেন্ট্ৰেল ফুড লেবৰেটৰীলৈ পঠাব বুলি জনাইছিলে। উক্ত চিঠিৰ লগত পাব্লিক এনচাৰ ৰিপৰ্ট পাইছিলো। 10/7/96 চিঠিখন যদিও মই পাইছো 15/5 তাৰিখে। চিঠি পাই লগে লগে মই ইনডোৰ্স কৰিছো। পদক্ষেপক উক্ত সহিত এক মোৰ সহিত পাব্লিক এনালাইষ্টৰ কপি। চিঠিখন অফিচিয়েল ইনভাইট যোগেদি পাইছিলো য'ত তাৰিখ আৰু সিল পোষ্টেল মৰা আছিলে 12/5/1998. This fact is very important.
So
They have to send within 10 days, my lord, from the filing the complaint.
he has rightly received it on 15/5. 12/8 it was issued, 15/5 years issued, but it ought to have been issued long back,
96, my lord.
96.
12/5.
96 within 10 days, not otherwise 30 days, in the prosecution started.
Prosecution is started, and second aspect is matter, there are many decisions I have brought, if need be also, my lord. In the Food Administration Act also, Insecticide Act and Drugs and Cosmetic Act, where it says that, my lord, if within the time
It's not
it's
done.
not given, it's not sent, my lord, it is no purpose will serve because it will deteriorate.
Because samples life is,
So ice cream, my lord, 2 years it will not.
where is exhibit,
22, my lord, your lordship will find in the record, it is not in my hand also.
Kothakor?
Yes.
See the record, exhibit 20, exhibit co.
Exhibit 22 at page 68 of the record.
Exhibit 22 was?
By the notice, my lord.
No, here's received, we want to see both exhibit
Then-
22 and
then-
Prodorkho co.
Uh,
Official, Prodorkho co Citycon official, that is where the seal is
Yes,
there.
I'll just,
Page 22.
না তাত নাই আছে নেকি কোনটো দেখা উলান হয় উলান 22 These documents are not available with me, so I have not been
But that will be there.
Then it is in the record.
Yes.
I'll just show me because I have gone through the record. It's report. হাজিরা হলে না হবে এটা Here, my lord, give it আছে flag আছে flag is there, my lord.
Give a new flag. So I can identify.
One 72 are there. The rest are not available in record. Rest of the exhibit we have exhibited, those are not there.
Rest may not be necessary also.
Huh?
Rest may not be necessary.
So because rest no, well, that I have received on 15/5, the envelope is of 12/5 and all that. No,
That is what I'm saying, exhibit co.
I give it cause go are not there. But at that point of time also, my lord, while I have noted it down, all the pages, but those were not available. Even
But as per cross-examination, it said that it is there.
Co is there, my lord. Co and co is there.
My lord, public analyst report is received by the accused person.
Yes,
my
they
lord.
received.
from the evidence of the deposition.
Yes,
of
they are, this is not their
Not
case that
only
you have
the
not
fact is,
received.
my lord, when they receive,
That is
or
the,
whether, my lord, if within a period of 10 days, my lord, those, my lord, that report was sent to the accused persons, and particularly it is the, my lord, burden of the prosecution to prove that during the period of 10 days, we have not received the report, and regarding that, my lord, there is nothing in the record, my lord.
These two documents are
And
there.
those points were
That
earlier also
exhibit-
not taken, my lord.
no, in cross, this is their defense. In cross examination, they have exhibited.
Yes,
This
my
is the envelope, this was issued on such and such that postal envelope they have exhibited. This is there to see his examination.
my এখানে কি চাই দিয়ে না, কত চাইছিল?
If you come to
না, এই আছে। Evidence of DW2. DW2,
DW2,
DW2, that is important.
they had, this is not their case that they have not received it. This
Yes.
is their defense case that they have received it
Almost after 2 years.
almost after 2 years.
And
Now they, in proof of that, they say that admittedly say তেওঁলোকে 30 দিনৰ ভিতৰত আমাৰ পৰা লৰা আইচক্ৰীম চেম্পলটো ইচ্ছা কৰিলে চেন্ট্ৰেল ফুড লেভেললৈ পঠাব পাৰো বুলি জনাইছিল। উক্ত চিঠিৰ লগত পাব্লিক এনালাইচিছৰ ৰিপৰ্ট ডেটেড 10/7/96 চিঠিখন 27/8 চনৰ তাৰিখৰ যদিও মই পাইছো 15/5/98 তাৰিখে। চিঠি পাই লগে লগে মই এনড্ৰছ কৰিছো। প্ৰদৰ্শক ক উক্ত চহী ক এক মোৰ চহী পাব্লিক এনালাইচিছৰ কপি। প্ৰদৰ্শক ক অফিচিয়েল এনভেলপ যোগেদি পাইছিলো য'ত তাৰিখ চিল মৰা আছে তাত 12/5/98 তাৰিখ বুলি উল্লেখ আছে। উক্ত গ এনভেলপ আমি আগতে অফিচিয়েল চোৱাইছো। So the defense also has not disputed that it is not received on 12/5/98. The question is whether you have received on even after receipt পুৱাৰ 10 দিনৰ ভিতৰত CF হলে আবেদন আদালতত দাখিল দিয়া নাই। Their defense is not disputing that they have not received. What is the prosecution case is that after receive within 10 days you have not given. So certain facts are not being disputed either by prosecution or by defense. Your stand that we have sent it is not disputed by them. They said we have received it, but they said that I have received it on such and such date, and they exhibited. That exhibit is not doubted. No question on that exhibit. Rather, they say after receipt of it, whether within 10 days you have issued it. So if they received in 98, sample is of 96, methodence there. Whether it is the exhibit we see or not see in a revisional petition is different. We'll go by this cross-examination.
Yes.
Directly on that point,
Hmm.
the latest decision of 2022,
Give us.
20, madam. বুঝলি তো? তোমার copy বানাও। Two photo দিও।
They might have realized later on. That's why they have sent it and you have also received it, yes.
Into the- Madam, 2020 15 SCC 763. The judgment was written by my lord our former chief justice, madam.
Which paragraph?
Paragraph your lordship will find. But I'm not reading the entire. Paragraph 14 is important. At page 768. Lord, may I read your lordship? On this aspect of the matter, we take-
Paragraph?
Paragraph 14. my lord. Other parties factually, if need be, I'll read, my lord. if necessary.
No, not
But
necessary.
on this aspect of the matter, we take note that while adverting to the provisions of section 13(2) requiring to furnish a report of analysis to the accused, as contemplated in the learned judges, all the three courts have taken note of the evidence of PW2C Jaipal Singh, the foot clerk, who claimed to have displayed the report by registered post on 7/4/1980. The learned judges have, however, failed to take note that no evidence was, this is important, no evidence was brought on record to indicate that the report which claimed to have been discharged was actually served or delivered on the appellant. The very purpose of furnishing such report to enable the accused to seek for reference to the Central Food Laboratory for analysis. If the accused is dissatisfied with the report, such safeguard provided to the accused under section 13(2) of the Act is valuable right. In that view, even if the dispatch of the report on 7 is taken as substantial compliance, my lord, this is very important. Though it is beyond the period of 10 days from the from 1880, that is the date of which the prosecution was lodged. In absence of there being proof of delivery of the report to the accused, in the instant fact, the valuable right available to the appellant accused to seek the reference within the period of 10 days stands defeated. In that circumstances, it will have to be construed strictly in the I'm sorry, it will be have to be construed strictly in the facts and circumstances of the case. In the since as already noticed above, the report of analysis has not in fact been served on the appellant, and the mere dispatch of the report as per the statement of PW2 was not sufficient.
Now,
If
where
that be
where
the
is that prescription under 13.3? When is to be sent? Any
10
prescription?
days, within 10 days.
Within 10 days.
But that probably, my lord, they have done, my lord. I'll just see the year to Sassan Kaza, Gilani. In that particular case, that prescription was even not there. That was the argued by the, my lord, the counsel, my lord. But the Supreme Court says that forget about that. Whether it
Let
was
us see 13, section 13. FP, Food Adulteration Act.
Yes, Food Adulteration Act, a case of
Not the big one,
1996, my
small
lord.
one. Prevention of Food Adulteration Act. Let us understand section 13.
My lord, that the public analysis shall deliver in such form as may be prescribed a report to the local health authority of the result of the analysis of any article of food submitted to have been analyzed. On receipt of the report of result of analysis under subsection 1 to the effect that article of food is adulterated, the local health authority shall, after the institution of prosecution against the person from whom the sample of the article was taken, and the person, if any, whose name, address, and other particulars has been disclosed under section 14A, forward in such manner as may be prescribed a copy of the report of result of analysis to such person or person, as the case may be, informing such person or person that if it is so desired, either or both of them may take an application to the court within a period of 10 days from the date of receipt of the copy of the report to get the sample of the article of food found to be kept by local health authority, analyzed by the Central Food Laboratory. The D is important. 2D is also important. Until the receipt of the certificate of the result, my lord, then they will follow. If I file an application, it will be sent. Now, until the receipt of the certificate of result of the analysis from the Director of Central Food Laboratory, the court shall not continue with the proceeding pending before it in relation to the prosecution. One of the appellate court says that you have not applied even after receiving it.
How you answered it?
So that answer is that, my lord, after 2 years, my lord. The my lord is in the meantime already trial started.
See, under 13.1, let us debate on it. Under 13.1, what is the prescription? The public analysis shall deliver in such form as may be prescribed a report to the local health authority of the result of analysis of any article of food submitted to him for analysis. So first is he will submit to this authority. Now, on receipt of report of result of analysis under subsection 1 to the effect that article of food is adulterated, the local health authority shall, after institution of prosecution against the person from whom the sample of article food was taken, and the person, if any, whose name, address, and other particulars have been disclosed under 14A, forward in such manner as prescribed a copy of the report of result of the analysis to so persons as the case may be, inform such person or person that if it is so desired, either or both of them may make a application to the court within a period of 10 days from date of receipt of the copy of the report to get sample of the article of the food by the local health authority analyst to second level. You have waived this right even if you have received after 2 years. That is and therefore their cross-examination is to that effect.
Yes.
Whether, okay, they accepted that, okay, you have received it. Whether at that stage you have raised anything against your right. Your contention is that why should we raise a right because which will be a futile exercise. Futile exercise. But there is no prescription under the Act to submit the report within a specific period. We'll have to make an interpretation saying that it cannot be unlimited because the right will be extinguished. Any law on that point?
Case laws are there.
Yes.
Back to the.
See, the plain meaning of text is not prescribing any period
Yes.
for delivering a report. So if that be so, in absence of anything, we'll have to come to a conclusion that it cannot be unlimited. It must be a reasonable period for the reason that his right can be successfully or it can be, he can get the benefit of such.
In case, my lord, those points were raised at that point of time, then court will decide, my lord, whether ultimately, my lord, that litigation will any result.
Which judgment, Mr. Agarwal?
Coming, your lordship will finally,
Hmm.
this second part. First part, my lord, they are all related to 13.2.
Hmm.
Lord, I have not cited this. I have
Not
my
necessary.
lord.
See,
These are-
13.2, what we understand is that moment they will have to send it to the local food analyst. Local food analyst will do it, send back to them, and they will have to serve them. Law is well settled. Only presumption will know the actual service is to be proved. Here, in your case, that it was served is no doubt. So therefore, that proof is not required. You have also not raised, everything is this. So that report was received. And after receipt, admittedly, by virtue of them not challenging that date, saying that we received it after 2 years, that also remains established, that it is received after 2 years. Now, the learned court proceeded in the context that since you have not raised your objection within 10 days, even of the repeated or belated receipt, therefore you have lost your right. Now, I want to know some determination, if any, to suggest that this period of service notice, no, there is no prescription. It must be within a reasonable period of time. And what is reasonable period of time is to be defined. So 2 years, we'll have to come to a conclusion that 2 years cannot be a reasonable time by virtue of the nature of the sample. Because it cannot be sent once again that sample after 2 years.
Yes, yes.
So anything on that, rest forget about that.
Yes, my lord, your lord will kindly, my lord, I have given the bunch of case laws.
Which one?
My lord, flake, your lordship will finally, flake, 13 onwards.
Please 13 onwards.
Flake, my lord.
Yes.
Now that is in the 13 is on the first, well, the first case, my lord. That case has been relied twice, my lord. The first case.
State of Punjab.
State of, no, my lord, Municipal Corporation of Delhi versus Gisaram, my lord. The first case, my lord. Flag 1.
Flag 1.
That is the case relied twice, my lord.
Municipal Corporation. Okay.
Gisaram. May I?
Okay, that's clicks the issue. One judgment.
You know, that is the para 7, my lord.
Para 7.
Yes, para 7. That is the. No, there are subsequent decisions.
One is enough.
I am saying that is food alteration.
And any recent on the basis of relying on this? Anything?
Not
One more.
recent decision.
1967. Let us come. Later
My
part.
lord, your lordship will find I have given up to 2016, my lord.
Where is that?
2016 is at flag 220. This is under Insecticide Act, my lord. কিমান আছে In the background of the aforesaid story provision, it was submission of the Learned Council for the appellant that the time, by the time the matter came to be taken up by the learned additional civil judge so and so, the sample has already expired. In this behalf, it was pointed out that sample was drawn on to expire in August 95. Thus, viewed it was asserted that the only right vested in the accused to controvert the report of analysis. Of the
What
sample
is
of
subsequent, anything as regard similar provision in the new
insecticide.
act, not insecticides, new act, FSSI, any provision
I have not looked into
or
it.
prescribing some time? Anything legislature has changed it?
And
What I will look in.
so far the Food Nutrition Act 2009-15 SCC.
Hmm.
Another decision is there.
2009-15 SCC page
My lord, this is my lord 18, my lord, flag 18.
18.
There are 9 to 11, my lord. Ghisaram was referred, para 9. Very short judgment, my lord.
Okay, Bothakur.
Yes, otherwise prima facie also, my lord, there is no meaning of sending a sample after 2 years, my lord, no purpose will be served. my lord.
Heard Mr. K. Agarwal, learned senior counsel, assisted by Susan.
Judgment is reserved.
Hmm?
Judgment is reserved.
Dictating. Nothing is being kept.
I thought that, my lord. No, it will be pressed in the mind, my lord.
Press in the mind. There may be some delay in uploading, correction, fine
That's a
tuning.
different thing.
That is otherwise if
My
it
lord,
goes
both the petition will cover. my lord.
common sense. Mr. Bothakur, that UAP judgment is reported.
Yes,
That's reasonable. What
No,
should be the reasonable
it is-
time?
reported last December or November.
Can you get the citation
Lots.
right now?
I will.
Because the same principle will be
Lots.
applicable.
Lots.
That what should be the reasonable
Lots.
time?
Lots. This
When there
provision-
is no prescription by the legislature as per time, it relating to the situation, it must be
I
reasonable.
will bring it to your attention.
Okay, hard in part, list this matter for further hearing on, give a date only on that will dictate the order. No further hearing, but huh? No, before vacation, we'll dictate, complete it. No, your presence is not required.
Next week I will not be available.
No, your presence is not required. We'll just dictate this order, collect this.
Your lordship, in rule 7, probably there is a time limit. Your lordship may
No,
kindly.
that time limit is for my lord giving the report by the public.
Public and-
Not report by the public.
No.
Here, it was delivered, admittedly
Right.
delivered after 2 years.
Right.
Now, what will be the purpose will be served? So it is, since it says that it is not only registered for, it is on your responsibility to deliver it. So because the right accrues. So we'll go through once again. I'm keeping this when next week. 16th.
I'll be not there. my lord.
No, not necessary. Ask her to be here. Just a minute, sir. Just ask her to, I have taken, just give the dates when it was
I'll just.
inspected, then analysis report was sent, received, all these dates. I have noted it down, but still.
I'll be getting it typed in.
Yes, yes,
forward.
that will be better.
I
That
think,
will be better.
very shortly
Yes, yes.
on this point.
If that can be
In
before
these
that,
points,
if that can be before that date,
before the date, I can.
Ah.
By tomorrow, I think,
yes,
by tomorrow or by Monday,
by month.
definitely.
Okay. Yes, next case. Three and four together, I think.
2 and 3 together.
Okay, four.
4 is different.
What is four?
4, my lord, here the basic facts is, my lord.
Hmm.
Lord, the complainant and the accused
Hmm.
are related to each other.
Hmm.
Lord, I have married the sister-in-law of the complainant. Now, my lord, the case is that, my lord, I came to Lamding. I am a resident of Delhi, my lord. I am residing at Delhi, my lord.
Hmm.
I came to, my lord, Lamding, and my lord, I told the complainant that why don't you invest in, my lord, shares and other things. So I insisted on her on different time. After 1.5 years, my lord, she invested in the shares.
Hmm.
And my lord, she paid around 64,000 on odd and 45,000 on odd. 1 lakh something she has paid, 1,09,000 on odd. Out of that, it is the case that I have, my lord, she has received, my lord, around shares of 30,000. And thereafter, she, my lord, filed a complaint petition, and simultaneously, my lord, she filed an arbitration proceeding before the, my lord, Delhi Exchange. And that was decided also there. They said that since you have not been able to place any material for non-supply of the shares in respect of the 64,000, but you have been able to show that in respect of 45,000 which you have paid, 30,000 amount already paid to you, 30,000 shares already allotted to you and given to you. Rest 14,000, I was held to be a defaulter there. So they said that from the exchange we will pay 14,000 or not. He did not accept.
Then file the complaint. Complaint was filed.
Complaint filed earlier, it seems to be.
I'll
I'll just see.
Complaint filed
Complaint
earlier,
filed earlier.
but subsequently these things happen. What is the allegation? Is the complaint?
I'll come. Your lordship will kindly come to page 27.
Anybody is interested as on date?
Yes, ma'am.
Huh?
Yes. Already another case is pending before Supreme Court. Ma'am.
What is that?
Against the son, my son is there also misappropriation of money, man.
Oh, that case has nothing to do with this.
Anyway, but
This
that
case
but
has
conduct of
nothing
the
to do
accused is that man.
Where is the complaint?
Complaint at page 27. My lord, page 27, may I read? Firstly, page 28, my lord, I'm reading the third paragraph. That accused coming to the residence of our complainant at Lamding induced our complainant to purchase shares of companies where he was connected with. It was about first week of March 1997. Again, the accused persistently was making inducement over phone and once again personally coming to your appellant's residence at Lamding. In October 1998, my lord will kindly see the date is very important. My lord, I started insisting from March 1997. October 19, the complainant honestly believing the accused entrusted him with a total amount of rupees 1,09,000 and in total with a view to invest the amount in purchasing shares. The accused sent the following details bills in the complainant. The details bills, my lord, your lordship will find 64,000 an odd and 45,000 an odd. Accordingly, on receipt of the above bills sent by the accused, the complainant remitted check number itna, AC pay check number itna paid in favor of HB Ralhan and Company. The amount was paid by check to HB Ralhan and Company, my lord. And the accused collected the amount from the bank, Punjab National Bank, Kirtinagar, and on 3/11/1998, 25/11/1998 respectively. The accused, as per the instruction, was to send share certificates to the complainant at her address at Lamding. The accused sent only 2 genuine certificates of the following descriptions, the 30,000 and odd, my lord. The accused did not purchase the shares and just sent all fake bills of the rest amount of rupees 78,990 and thereby dishonestly misappropriated the amount entrusted to him. On this, there is no evidence. On 15/3/2019, the accused was personally approached and they inquired about as to why he did not purchase shares. He, while admitting his guilt, has refused to refund the amount in spite of repeated requests and asking, and ultimately he seized all the contract and relations. All the money remitted to him by check was deposited in his account. The complainant was so long hesitant to approach the court. Your Honor, will kindly see, this is important. Because the accused happened to be the husband of the younger sister of the complainant's husband, Subhash Jadhav, Vasudev. But the act of the accused has caused immense injury to the mind and body of the complainant besides causing monetary loss. Had the accused not induced the complainant to believe honestly that he would purchase the shares as per the complainant's instruction, the complainant would not have paid the amount as mentioned above. So this is
Now,
what-
where are the statements?
evidence, my lord, your lordship will find. I have given the my lord separately to my lord, my lord. Those are very important.
Once they were acquitted, my lord, again.
Hmm?
Once he
I
was
was
acquitted,
acquitted once, my lord.
acquitted once.
The complainant came to the High Court. High Court has remanded the matter.
appealing and
Earlier, the
acquitted.
charge was under section 420.
Hmm.
Later on, my lord, there was an application for alteration of charge from 403 to 409.
Hmm.
But, my lord, in fact, my lord, there was no charge under 403.
Hmm.
So, my lord, the Honorable Court added 409 as a
By High
request
Court.
by the trial court. My lord, I'll come to that, my lord. I have given all the facts here, my lord.
So this happened, then this proceeded,
Yes, ma'am.
this complaint proceeded. Then he was acquitted.
He earlier acquitted, man. Justice Agarwal, PG Agarwal judgment is there. So that judgment you also pays 43, man.
Page 43.
Then they
Now fresh evidence you have taken or on
yeah,
the
matter
basis
was
of
remanded by both.
Was remanded.
Ah.
They did not give any evidence for that.
Both parties were given
They
evidence.
said, well, I'll come to that. That respect, I'll.
just tell me the fact before going details.
Female, that was also rejected. Man.
That's true. That's true. That fact I have stated in my ear.
No, just tell us. I thought that this is only quashing of that complaint only.
No,
So
not
that-
passing, not passing.
Okay.
My lord, trial has been, my lord, I have been convicted by the trial court
Hmm.
for 3 years and with fine.
Hmm.
For both the sections, 402 and 409, 420 and 409. Appellate court also, my lord, confirmed the judgment and I am before my lord.
So in first round, you were acquitted. In the second round, you were
Convicted.
convicted. How many witnesses?
Two witnesses.
2 witnesses only.
And there is admission of documents were there also. Man.
Two witnesses. Okay, then let us see these two witnesses first.
Yes, it is important.
PW1 and PW2.
PW1 and PW2, my lord, I have given the, my lord, separate paper book, my lord. Page 11. My lord, I have given a type copy, my lord. Your lordship need not to, my lord, here. Page 11 is type copy. I have given the certified copy also. If any difficulty, your lordship find. মই আছামী ৰাকেশ ৰাণাৰ ওপৰত এই বছৰ কৰিছো। তেওঁ দিল্লীৰ কেৰেলবাগত থাকে। তেওঁ ডেইৰী এক্সচেঞ্জ ষ্টেক ব্ৰকাৰ আছামী ৰাকেশ ৰাণাৰ পত্নী সুনীতা মোৰ স্বামীৰ ভৰু ভনী। মই লামডিং কলেজৰ লেকচাৰাৰ ৰাকেশ পাহাৰাৰ শহুৰৰ ঘৰ লামডিঙত 1997 চনৰ মাৰ্চ মাহৰ পহিলা সপ্তাহত ৰাকেশ লামডিঙলৈ আহিছিল আৰু মোক লগ পাইছিল। তেওঁ মোক শ্বেয়াৰত মোক ইনভেষ্ট কৰিবলৈ কৈছিল। তেওঁ মোক দিল্লী ষ্টেক এক্সচেঞ্জৰ পৰা শ্বেয়াৰ কিনিবলৈ কৈছিল আৰু তেওঁ সেইবোৰ বন্দোবস্ত কৰি দিব। মই প্ৰথমত মান্তি হোৱা নাছিলোঁ যদিও মোক বহুবাৰ ফোন কৰি শ্বেয়াৰত টকা লগাবৰ বিষয়ে মোক কৈছিল। তেওঁ কৈছিল যে এইটো এটা ভাল ব্যৱসায়। তেওঁ পিছত আকৌ এবাৰ লামডিং আহিছিল। 1.5 বছৰমান পিছতে মই শ্বেয়াৰ কিনিবলৈ সন্মত হ'লোঁ। This is very important fact. আছামী ৰাকেশ ৰাণাৰ শ্বেয়াৰ বিজনেছত ডিল কৰা এটা কোম্পানী আছে নাম HB ৰাণান কোম্পানী। ৰাকেশ ৰাণান মোক কৈছিল যে শ্বেয়াৰ কিনিবৰ বাবে চেক পঠিয়াব হ'লে তেওঁৰ কোম্পানী HB ৰাণান কোম্পানীৰ নামত পঠিয়াব লাগিব। সেইমতে দুখন চেক এখন ইমান টকা আৰু ইমান টকা শ্বেয়াৰ কিনিবৰ কাৰণে HB ৰাণান কোম্পানীলৈ পঠিয়াইছিলোঁ। চেকখন পাঞ্জাৱ নেশ্যনেল বেংক টিটিনগৰ ব্ৰাঞ্চ নিউ দিল্লীত আছে। তাৰপিছত প্ৰশ্ন, পাঞ্জাৱ নেশ্যনেলৰ টকাটো HB ৰাণান কোম্পানীৰ নামত যে জমা হৈছে সেই বিষয়ে মোক জনোৱা প্ৰমাণপত্ৰ। ইয়াৰ পাছত ৰাকেশ ৰাণানে মোলৈ 30,000 টকাৰ শ্বেয়াৰ চাৰ্টিফিকেট পঠায়। My lord, your lordship will find here that 420 goes, my lord. ইয়াৰ পিছত ৰাকেশ ৰনে মোলৈ 30,000 টকাৰ শ্বেয়াৰ চাৰ্টিফিকেট পঠায় 1 ডিচেম্বৰ 1998 চনৰ কথা এইটো হা উপৰোক্ত চেক দুখন ৰাকেশ লামডিঙত আহি মোৰ পৰা সংগ্ৰহ কৰিছিল মই চেক পঠোৱাৰ আগতে ৰাকেশৰ মোলৈ কেইখনমান বিল পঠাই দিছিলে তেওঁ মই কিমান টকা পঠাব লাগে তাৰ বিষয়ে তেওঁ নিজ হাতে মোক এটা হিচাপ কৰি দিছিলে এক্সিবিট 6 সেই হিচাপ কৰি দিয়া কাগজখন 2 3 4 5 7 8 হল সেল বিল কেইখন 7 and 8 খন মই চেক পঠোৱাৰ পিছত মোলৈ পঠোৱা হৈছিলে এই দুখনত মই 30,000 টকা শ্বেয়াৰ চাৰ্টিফিকেট মোৰ নামত কিনিব বুলি মোক জনোৱা হৈছিলে এক্সিবিট 2 যোগে 7,173 টকা ইমান আৰু ইমান যোগে ইমান these are different amount এক্সিবিট 2 পৰা 6 লৈ কোনো শ্বেয়াৰ চাৰ্টিফিকেট নামত উল্লেখ নাই সকলোবোৰ সেল বিল এছবি ৰিলায়েন্স কোম্পানীৰ পৰা পঠাইছিলে 14,000 টকাৰ এখন সেল বিল মোলৈ পঠোৱা হৈছিল কিন্তু সেল বিলখন মোৰ হাতত মিসপ্লেস হৈছে এই আদালতত দাখিল দিব পৰা নাই মই টকাৰ হিচাপটো এক্সিবিট 6ত আছে টকাৰ হিচাপটো এক্সিবিট 6ত ৰঙা চিয়াহিৰে বেৰ দি ৰখা হৈছে ৰুপিজ ইমান টকাৰ মই কোনো শ্বেয়াৰ চাৰ্টিফিকেট আজিলৈকে পোৱা নাই মই ৰাকেশ ৰাণক শ্বেয়াৰ চাৰ্টিফিকেট নিদিয়া টকাখিনি ঘূৰাই দিবলৈ তাৰিখ দি আহিছো কিন্তু তেওঁ মোক ইমান টকা ঘূৰাই দিয়া নাই সাক্ষী সুভাষ বাসুদেৱ মোৰ স্বামী সাক্ষী সুৰেন্দ্ৰ শৰ্মা বৰ্মা আৰু মনীষ ঢাল এছবি ৰিলায়েন্সৰ কৰ্মচাৰী তেওঁলোকক এই ঘটনাৰ বিষয়ে জানে ইমান 2 3 4 5 খন ফলছ বিল যে কেইখন মোলৈ পঠোৱা হৈছিল যিহেতু ৰাকেশ মোৰ সম্পৰ্কীয় হয় হে তেওঁৰ পৰা বাকি টকাখিনি ঘূৰাই পাম বুলি আশা কৰিছিলো এহে গোচৰ দাখিল দিয়াত পলম হয় প্ৰদৰ্শক 9 মোৰ গোচৰ মূল দৰখাস্ত স্বয়ংক্ৰিয় সহি আসামী ৰাকেশ মোক শেষত ক'লে যে তেওঁ মোৰ ইমান টকা ঘূৰাই নিদিয়ে আৰু সেই টকা কোনো শ্বেয়াৰ চাৰ্টিফিকেট মোৰ নামত নিকিনে মই যি কৰো কৰিব পাৰো মই ৰাকেশক
খুব বিশ্বাস
হা
খুব বিশ্বাস
বিশ্বাস কৰিয়ে শ্বেয়াৰ চাৰ্টিফিকেট টকা ইনভেষ্ট কৰিছিলো আগবাঢ়িছিলো অন্যথা আগবাঢ়িলোহেঁতেন মই গোচৰ মূল দৰখাস্ত কৰিছো ইয়াৰ পিছত সহি কৰিছো ন ক্ৰছ এক্সামিনেশ্যন এছবি ৰিলায়েন্স কোম্পানীৰ বিজনেছ টাৰ্মছ এণ্ড কণ্ডিশ্যনৰ বিষয়ে মই জানিবলৈ এই কোম্পানীৰ লগত বিজনেছত নামিছিলো ৰাকেশৰ কোম্পানীৰ নামত দিয়া চেক দুখন প্ৰথমতে মই ৰাকেশ ৰাণাৰ লামডিঙত দিছিলো দ্বিতীয় চেকখন মোৰ স্বামী দিল্লীলৈ যাওঁতে তেওঁ লৈ যায় আৰু ৰাকেশ ৰাণাক দিয়ে ৰাকেশে মই চেকখন মোৰ ঘৰত দিছিলো এই কেছটো কৰাৰ আগত মই এই ঘটনাৰ বিষয়ে দিল্লী এক্সচেঞ্জত আৰ্বিট্ৰেশ্যন দিছিলো but this fact is very important এছবি ৰিলায়েন্স কোম্পানীৰ ফুল ফৰ্ম মই নাজানো এইটো তেওঁলোকৰ পাৰিবাৰিক বিজনেছ হ'ব পাৰে আসামী স্ত্ৰী মোৰ স্বামীৰ সৰু ভনী প্ৰদৰ্শক 1 পৰা 6 লৈকে আসামীৰ সাক্ষ্য কোৱা সহি দেখা নাই in all the exhibits there is no signature of the accused প্ৰদৰ্শক 7 আৰু 8ত ইনিচিয়েল আছে কাৰ ইনিচিয়েল মই নাজানো নৰ্থ পাঞ্জাব নেশ্যনেল বেংকৰ মেনেজাৰ সহি দেখা পাওঁ তেওঁ নাম নাজানো নৰ্থ আসামী ৰাকেশ ৰাণৰ টকাটো উঠাইছে তাৰ বিষয়ে একো নাই ৰাকেশৰ লামডিং মোক ব্লক কৰাত মই 2জন চেক তেওঁৰ হাতত দিছিলো বোধহয় 31/9/98 চেক কেইখন দিছিলো সেকেন্ড চেকখন মই মোৰ স্বামীক দিওঁ তেওঁ ৰাকেশক দিয়ে এছবি ৰিলায়েন্স কোম্পানীৰ টাৰ্মছ এণ্ড কণ্ডিশ্যনখিনি নাজানো এছবি ৰিলায়েন্স কোম্পানী দিল্লী এক্সচেঞ্জ ব্ৰকাৰ শ্বেয়াৰ চাৰ্টিফিকেটবোৰ মোৰ লগত আছে আদালতত দাখিল দিয়া নাই এছবি ৰিলায়েন্স কোম্পানীৰ অফিচিয়েল টাৰ্মছ এণ্ড কণ্ডিশ্যন দেখাৰ মই প্ৰয়োজন বোধ কৰা নাছিলো ইয়াৰ বাহিৰে মই এছবি ৰিলায়েন্স কোম্পানীৰ পৰা শ্বেয়াৰ কিনা নাছিলো প্ৰদৰ্শক 1 পৰা 3 লৈকে কোনো কাগজত আসামী ৰাকেশ ৰাণা এছবি ৰিলায়েন্স কোম্পানীৰ প্ৰপ্ৰাইটাৰ বুলি উল্লেখ নাই পিএন বেংক দিল্লী ব্ৰাঞ্চ মেনেজাৰ মই গোচৰ সাক্ষী কৰা নাই আৰু বাকি টকা ঘূৰাই দিবলৈ কৈছিলো মাৰ্চ 99 পৰা পিছত মই ডিসিজন লৈছিলো যে কেছ কৰিব লাগিব soon after middle of March 99 কেছ কৰিম বুলি ডিসিজন লৈছিলো সত্য নহয় যে ৰাকেশ মোৰ 2 পৰা 4 8 লৈকে কোনো বিল দিয়া নাছিল সত্য নহয় যে 1 পৰা কোনো সত্য নহয় যে প্ৰদৰ্শক 1 পৰা কোনো সত্য নাই সত্য নহয় যে ৰাকেশ ৰাণাৰ লগত টকা দি শ্বেয়াৰ কিনাৰ চুক্তি কৰা নাছিলো সত্য নহয় যে ৰাকেশে মোৰ পৰা কোনো ধৰণৰ ঠগা নাছিলে এছবি ৰিলায়েন্স কোম্পানীৰ ওপৰত সিভিল কেছ হলে দিল্লী হাইকোৰ্টৰ জুৰিডিকশ্যন হ'ব আৰু ক্ৰিমিনেল কেছ হলে মোৰ এৰিয়াত হ'ব পাৰে কাৰণ মই ইয়াত লামডিঙৰ ৰাকেশৰ লগত চুক্তি কৰিছিলো সত্য নহয় যে SB Ralan Company লগত হোৱা যিকোনো কেছত দিল্লী হাইকোৰ্টৰ ডিৰেকশ্যন হ'ব। It is not a fact that I did not explain the delay properly. Now next, মোৰ স্বামীৰ লগত পৰিয়ালৰ অন্য সদস্যৰ মাজত কেছ আছে। But we have brought that there is an enmity. There are several cases are pending in between. The next evidence is of
ফাদার কত?
further cost. এতিয়া মই SB Ralan Company একাউণ্ট পেজ চেক দিওঁ, তেতিয়া শ্বেয়াৰ কিনিব হ'লে ডিমেট একাউণ্টৰ প্ৰয়োজন হয়, কিন্তু তেতিয়া মোৰ ডিমেট একাউণ্ট নাছিলে। যি কোম্পানীৰ শ্বেয়াৰ কিনিবলৈ মই ডিটেইলছ চেক মোৰ স্বামীৰ হাতত দিল্লীলৈ আসামলৈ পঠাওঁ। শ্বেয়াৰ কিনিবলৈ বিচৰা কোনো ফৰ্মত মই চহী কৰা নাছিলোঁ। এই ঘটনালৈ মই দেহলি এক্সচেঞ্জত এখন কমপ্লেইন দিছিলোঁ। তেওঁলোকে প্ৰথমে মোক জনায় যে যিহেতু চিভিল লাইবিলিটি, পিছত তেওঁলোকে জনায় যে আসামী এজন ডিফল্টাৰ হয়। মোৰ স্বামীক কীৰ্তিনগৰ থানাৰ আসামীৰ বিৰুদ্ধে কিবা গোচৰ দিছে নে নাই মই নাজানো। মই মোৰ সাহিত্য উল্লেখ কৰিছোঁ যে accordingly on receipt of the above bill sent by the accused, the complainant limited rupees ইতনা in favor of SB। সত্য নহয় যে এক্সিবিট 6খন আসামীৰ নিজৰ হাতত লিখি পঠোৱা, সেইখন মই বনাই লৈছোঁ। সত্য নহয় যে মই অভিযোগ কৰা ইমান টকা আসামী ঘূৰাই দিয়া নাই। মোৰ শহুৰ এতিয়া মোৰ দেৱৰ সুশীলৰ ঘৰত আছে আৰু আসামী লামডিঙত আহিলে তেওঁ তাত থাকে। আমাৰ বাসুদেৱ পৰিয়ালৰ মাজত এটা অন্য গোচৰ চলি আছে। সত্য নহয় যে মোৰ আসামীৰ লগত তেওঁৰ সৰু ভাই সুনীল বাসুদেৱৰ লগত পৰিয়ালৰ ডিস্পুট লৈ গোচৰ চলি থাকোঁতে আৰু সেই গোচৰত আসামীয়ে পুলিচৰ পক্ষ লোৱাতে মই আসামীৰ বিৰুদ্ধে মিছা গোচৰ দিছোঁ। সত্য নহয় যে আসামীক চেক দুখন দি মোৰ এই শ্বেয়াৰ কিনিবলৈ ইণ্টাৰেষ্ট কৰা নাই। সত্য নহয় যে আসামী মই চেক দুখন Now PW2 is paid 26 my lord, my type copy. বছৰীয়া মোৰ পৰিবাৰ, আমি দুয়ো একেলগে লামডিঙত থাকোঁ। মই দিল্লী উচ্চ ন্যায়ালয় আৰু উচ্চতম ন্যায়ালয়ত ওকালতি কৰোঁ।
What is that? Yes.
বছৰীয়া মোৰ পৰিবাৰ, মই দুয়ো একেলগে লামডিঙত থাকোঁ। মই দিল্লী উচ্চ ন্যায়ালয় আৰু উচ্চতম ন্যায়ালয়ত ওকালতি কৰোঁ। বৰ্তমান মই ক'তো ওকালতি নকৰোঁ। সাময়িকভাৱে ছাছপেণ্ড কৰি ৰাখিছে আসামী ৰাকেশ চৰণ, মোৰ ভনীৰ স্বামী। ৰাকেশ চৰণ দিল্লীত থাকে আৰু তেওঁ দিল্লী এক্সচেঞ্জৰ সদস্য। প্ৰদৰ্শক ডক্টৰ ৰাকেশ চৰণৰ মোক দিয়া
What is the offense he have been convicted?
420 and 409.
409. And what are this arbitration and all?
My lord, your lordship will find they have not exhibited. Your lordship will kindly come to the main paper book, main book, my lord.
Sum and substance that you convince her to make investment in share market. Okay, that may not be an inducement.
According to the inducement.
Okay,
because
let,
several occasions he-
no, I'm not taking any views, just thinking as a whole perspective. Inducement, according to him, that it was a share investment dealing between both of them. He promised that he will invest in somewhere, but he did not invest that amount.
full amount he did not invest.
No, did not invest, and also did not return the amount. He has not disputed that part. There is no specific thing
There is a
that,
dispute, but my lord, assuming for the time being, my lord.
Ah.
Even
so
assuming-
in that context, your thing will be that it can be an agreement for investment, and but his case will be that since you have not invested, neither returned, that itself shows that there is you have an initial deception in your mind, thereby you induce me to pay you the handover, entrust you with the properties, and you have dishonestly misappropriated. This is your case.
Yes, I think this is basically.
And so far relating to the period, you are insisting on the period that it take two years. There can be two arguments. One is that you applied your mind and
That's what.
invested.
Yes.
And his case is that so continuously induced, I fell to his inducement.
I have parted with the money.
And I parted with the money. After vacation.
Yes.
It is a 50-50 case.
But-
It is a 50-50 case. This will be in my bench in the month of January.
No, my lord, I'll throw some.
I'll have to apply
I'll-
my
no,
mind.
no, that's true, my lord. Lordship will kindly consider one aspect of the matter, my lord. There is a Supreme Court decision, so I'll place before my lord. 420 and 409 cannot go together on the same facts.
Okay.
But
So
there
it
is no bar, my lord.
So
No, no,
I'll-
that's
I'll-
this is
it's not that, but it's not a
this
question.
is a case. What I can say is this can tilt this side also, and this can go.
And
that
moreover,
side.
this is, your lordship is exercise revision, that is another difficult.
That is
No,
another.
true. Revision, my lord, lordship.
So that's why I'm not going to in details all those things.
Because jurisdictional
Yeah.
point, they have argued.
No.
That was rejected, but they have not challenged that.
So far, revision is concerned, my lord, your lordship is, my lord, entitled to look into, empowered to look into the evidence.
Everything is there, but to what extent
Yes.
we will have to decide. There is a self-restraint also.
Yes,
Until and unless there is absolute miscarriage of justice comes into our mind, patent illegality,
perverse finding,
perverse finding,
evidence, not admissible evidence has
That
been
is
taken into
accepted
consideration,
and
admissible
it is
evidence not taken into consideration.
not-
These are the
these are the grounds.
And my lord, I'll confine to that one,
You confine to that one.
not beyond that. The
The
recent
two
Supreme-
witness only, so
the
we'll see
recent
the.
Supreme Court decision say that since you have already delivered some of the goods, not delivering the rest of the goods, it will be a civil liability. It cannot be a 409, 420 and all that.
Okay, that will be one of the grounds that I did not have any initial
no.
restriction. So therefore, I have even returned the money to one part. I could not return.
in
That will
fact-
not ipso facto make it is a
In
criminal
fact,
liability.
in fact, my lord, I have offered them, my lord. I have had my clients discussion and also I said that whatever money, if you even say that whether I have taken, not taken, finish the matter.
Settle it before January.
Finish it.
It is up to the parties, I cannot.
I'm no. I told him, no, his client is not agreeing, then what to do? I
No,
conveyed
I'm
to my
not saying
friend.
blaming him. You can
No,
see, we have also
it-
expressed. That's why I've said amongst the families,
Because the-
ultimately,
79,000, take some interest, finish it.
That's how it-
There is no difficulty. Why should my lord unnecessary, my lord, after
he's
all?
expecting that moment the conviction is upheld, then there will be a compromise before Supreme Court.
That is ultimately that will be.
That will be.
But
Suppose,
I have given my view, my lord, yeah, my lord.
suppose we upheld the conviction in revision, there will be scope of compromise before Supreme Court because you will be in a lesser bargaining position. But at this stage, he is in a higher bargaining position. Bargain it. Nobody is interested with any conviction. On whole thing is the money. I was expecting a huge return by investing. He has not done. Do something in between. Ah.
He's not invested, that is the problem. Well, he
That-
invested.
he has-
I'll come. He's not said. That is not the case. It was invested, bills were get. That's what the, my lord, Delhi Exchange, they have given a finding that that 64,000, the share certificates were sent along with the bill. You have not been able to prove that no share certificate in issue.
But that was not a defense in the 313 by law. This 330 says, I'm not a partner of that company.
Oh, that's,
That he has the-
I can take a false defense, my lord.
That is the.
They have to prove the case, not me, my lord.
Okay, we'll come back. January, second part.
Huh?
Second
Malady-
part, after Bihu.
Third.
If give a date as per your convenience. We could understand a little bit. Now we'll think of
23rd.
23rd, possible?
Yes.
23rd. Keep this inside the file. Okay.
That my lord, no, I'll try if possible, will give.
Yes. Yes.
Lordship, this is an appeal against the conviction provided by the judgment and order dated,
Criminal appeal.
yes, Lordship. Against conviction, Lordship, as a
Or
appellants
for how much under section?
under section 304 part B, Lordship,
Mm.
of the IPC and under red bit 149 of the IPC, Lordship, whereby the appellants were given imprisonment for 5 years, rigorous imprisonment 4 years.
You are outside or inside?
Lordship, because I'm the legal aid counsel here, so I have no contact with the. But supposedly, Lordship, 2011, so when the sentence period is over almost.
Over. What is to be done? Decision appeal by the petitioner, but subsequently
Subsequently, I was appointed as a legal aid counsel, Lordship, on 30/3/23, Lordship.
24 witnesses. in total.
not if he is already, I think, out of the, he'll be out of the jail. Isn't it?
Yes, sir, Lordship. Actually, yes.
What is, can you close it like this? That sentence is over, nobody is representing, only legal counsel is there, she'll close it.
I will get an instruction from the jailer where.
You have an instruction from jail. We are listing this matter on Monday.
Yes.
Monday, Lordship.
Monday.
Obliged.
But if he's out, then we'll not give much things, we'll close it.
Lordship.
Has, if somebody is interested that my conviction should go, then of course we'll hear. But if
Gotcha.
he's not represented, legal aid counsel, we will give a genuine cases time. Monday,
Obliged, Lordship.
13th. Sixteenth.
Lordship. Council AM boy is on the way. He's coming.
Okay, next. Episode second. এখানে হেড করলো বাসখান কেটা আছে none appears for the petitioner on call. This matter again on January after view. Yes, next. Yes. বাকি বিলা
Meet result.
14. Huh? 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 আমি কই পৰা আৰম্ভ কৰিছো এইটো কি বিলা 14. What is this, Mr.?
Appointed as an amicus matter. I have gone through the record.
Okay, okay, okay.
But the sentence is minor under 376 minor. Detention is 5 years minor. But the basic allegation was that minor the appellant and the victim they were in a relationship minor and there was a breach of promise to marry and there was a date on 11/1/2007. Accordingly, minor according to the informant, the appellant attempted to commit rape
Mm.
and he actually succeeded in committing rape. And thereafter, my lord, this present FIR was lodged. However, my lord, in the evidence, my lord,
Mm.
there was no mention about what happened prior to that date.
Mm.
The entire evidence was directed to the incident on 11/1/2007. And regarding that, my lord, there are several contradictions also, my lord. Which, my lord, I can.
Contradictions were brought in by the
Yes,
defense.
yes. I also proved it, my lord.
Now he is outside or inside?
Outside.
This is criminal revision.
Revision, my lord.
Petition. Okay.
My lord, if your lordship will kindly see the FIR.
Mm.
FIR, my lord, is at page number 22.
Mm.
Says that for the last about 3 months, the aforesaid accused number 1 above name with a promise and influence to marry me has been living with me. He always used to give hope. Last on 11/1/2007 at night about 8 p.m. The aforementioned accused person number 1 called me and took me down below near END Road in a bamboo grove and committed rape. And when he was about to leave at that time, I pulled him and started raising halla. And then some nearby people came and took both myself and the opposite party in our own village in the house of Muhammad Aizuddin Ali. So that is the allegation in the FIR. Now, Lordship will kindly see the evidence of this girl at page number 25. There, my lord, she directly starts from that date, my lord. See here, my lord, she says that at that time my age was about 14 years. On that date at about 8 p.m. At night, I was working at house, and at that time the accused person came to our house and called me. And when I told him what happened, he pulled me, holding my hand, and by other hand gagged my mouth and picked me up and took me to nearby bamboo grove. When intercourse with me, he gagged my mouth and raped me. And after completion, the accused person put on his clothes and about to go. At that time, I caught hold of him and made halla. And hearing my halla, Hazrat and Mohar came. So there, my lord, she says that, my lord, the appellant had committed rape upon her. Now, if your lordship will kindly see the 164 statement, that
But-
is in page number 23. Here, my lord, there is no mention about any incident that took place on that date. Here she says
Page 20.
23.
23 I have seen.
Yes.
They have
on-
been living together.
Yes.
And where is the FIR you said?
FIR at 22.
22.
22.
And 23.
And
Yes.
my lord, most important.
These contradictions were brought in.
Yes.
Where is that?
At page number 26, my lord. Middle, my lord. It is not a fact that I did not state before police. She also does not state the same thing in her 161 statement. Before police, about the accused person came to my house and called me, caught hold of my mouth and took away me by lifting and about committing rape and about taking me to bamboo grove and coming rape and on my raising halla, Hazrat and Mohar came. And most importantly, my lord, these two apparently eyewitnesses, my lord, Hazrat and Mohar, they also do not support this witness, my lord. Hazrat's, Mohar's evidence is at page number 27. He says that I heard halla from the road and advanced towards the road, and on my arrival, I saw the informant is holding the shirt of the accused person, and the accused person is holding the hand of the informant. At that time, Hazrat came. I told them to release each other. Thereafter, we took them to the house of one Tara persons from the village came, and I had called on VDP secretary. And after my arrival, I saw the accused person has already left. There now, last line, the informant told that the accused person intended to marry her but did not marry, and the accused person said he does not know. So, had this person was an eyewitness, definitely the victim, the very first statement, which the victim would have told that some bad things were done upon her. Nothing, my lord. And regarding, my lord, the other witness, that is Hazrat Ali Mondal. Hazrat Ali Mondal, page number 29.
Page 29.
Page 29. The other eyewitness, my lord. Last line, he says, and on inquiry, complainant informed that for last many days, the accused person proposed to marry her, but did not marry. Further, she stated that the accused person had committed bad works. Late on, the accused person left, I also came back. So the suggestion was put, my lord, to this particular witness That is in my lord page number 30.
Where is the IO's evidence?
I owe my lord at page number
Who
34.
is this PW7?
PW7, my lord, is a
Not
doctor.
necessary.
Doctor. No.
PWA6,
6 is my lord, I did
PW5 is not necessary.
not necessary. 6 is my lord one teacher. He also has not seen the incident.
He is not necessary.
No, 7 is also my lord on VDP secretary, my lord.
Mm.
Nothing is there. And 8 is the medical officer, my lord. So he says that, my lord, he no violence mark anywhere on the body of person examined
When it was taken?
on 15/1. Date of the incident was 11/1. The 4 days.
Date of the incident?
11/1.
Who is IO? PW9?
PW
9.
9. 36. I have checked the 161 statements also, my lord. That was not there, my lord. Those statements, my lord. Last portion, my lord. The victim, Basia Khatun, did not state to me that accused gagging her mouth, drag her to the bamboo plantation and committed rape on her, and on her screaming, Hosrot and Mohor came to her. These are not there, my lord. 160.
Hard.
Yes, my lord, my lord,
Hard. Sir, you are as amicus, na?
Amicus.
Amicus, Swensu. The present application under section 401 of the Criminal Code of Criminal Procedure, 1971 is filed, challenging judgment and order dated 8/9, judgment and order dated 10/8/2009, passed by learned Assistant Session Judge Dhubri in session case number 43/208 under section 307 IPC, and convicting the petitioner for sentencing the petitioner to
5 years.
undergo RI for 5 years. Full stop. The further challenge is impugn judgment and order dated 18/9/2009, passed by the learned Session Judge Dhubri in criminal appeal 8/3/2009, upholding the conviction and sentence passed by the learned trial court assistant session judge. Full stop. As none represented the petitioner, this court requested, and this matter was pending since 2010. This court requested Mr. Swenso to assist this court. Accordingly, he has argued, he has gone through the record and assisted this court. Mr. Swenso, learned amicus curiae, contends that there is major contradictions and improvements in the testimony of the victim. Testimony of the victim, creating a serious doubt upon the trustworthiness of the victim, informant victim. He further contends that the eyewitnesses projected by the accused also did not support the case of the prosecution. Rather, did not support the case of the prosecution. According to him, the medical evidence also did not suggest any sexual violence upon the victim. Rather, it was specifically opined that the hymen of the victim was intact. He further contends that the accused has narrated different versions in the FIR, in her statement recorded under section 164 CRPC, in her statement recorded under section 161, and during her testimony before the trial court, and the defense was able to contradict such statements, establish such contradiction by following the process as prescribed under section 145 of the Evidence Act. In view of the aforesaid, according to learned amicus, it was the accused was entitled for an conviction. However, the learned courts below solely placing reliance on the testimony of the victim has convicted the petitioner and sentenced him to undergo the imprisonment for 5 years. Par contra, Mr. Borthakur submits that two learned courts has concurrently held the petitioners to be guilty, and therefore at this stage, this court may not like to reappreciate the evidence and reappreciate the evidence in as much as there is no perversity in the judgment and no patent defect and there is no patent defect or glaring illegality in the judgment resulting in miscarriage of justice. I have given anxious considerations to arguments advanced by the learned counsel for the parties. As the learned amicus has stressed upon the perversity, this court has perused the testimonies of the witnesses. In the FIR, the version of the victim informant is that she has been living with the accused for last 3 months, and the accused promised to marry her. However, on 11/1/2007, she was raped by the accused near the END road in a bamboo grove. When she raised hue and cry, one Muhammad Lee, what would
Aizuddin,
it?
my lord.
Huh?
Aizuddin.
Aizuddin Ali and other villagers came, and the opposite party then assured to marry her. Okay. According to her, at that point of time, the other accused person within bracket not sent for trial took away the accused person. After receipt, such incident took place on 11/1/2007, and the FIR was lodged on 13/1/2007, and statement of the victim was recorded under section 164 on 16/1/2007. In her statement, in her statement under section 164 CRPC, she stated that the accused had committed sexual intercourse with with her on assurance to marry her. For last 3 months, they were involved in such sexual relation. Though she initially did not agree, but subsequently under influence of Mary, she accepted. And at the relevant point of time, the accused fled away without marrying her. During her deposition in the courts, she stated that when she was working at her house and pulled her, holding her hand and gagged her mouth and picked her and took to the nearby bamboo grove and had sex with her. According to her, he gagged her mouth and raped her, and after that, accused put on his clothes, and while he was about to go, at that time, she raised alarm, and hearing alarm, PW3 and PW4 reached the place. During her cross-examination, her contradictions made in the FIR, as well as her statement made in FIR under section 161 CRPC and under section 164 CRPC were duly contradicted by the defense. The fact remains that in the FIR, during her testimony before the trial, the victim did not state anything about the alleged relation between them, and they are living together for a period of 3 months is not disclosed in the testimony, though she stated having an existing love revelation between them and staying together in the statement recorded under section 164 CRPC. And in her testimony, she projected a case of forceful kidnapping and rape. The two witnesses, that is PW2 and PW3, deposed that these two persons, that accused and informant, were quarreling under the street, and they intervened, and at that point of time, the victim told them that the accused person is now refusing to marry her. The investigating officer also, during his cross-examination, admitted that the victim did not state before him as regards accused gagging the mouth of the victim and taking her to the to the bamboo plantation and committing rape on her, and that on her screaming, Hajarat and Mohar came to rescue her. to rescue her from the aforesaid. It is true that the doctor, the incident took place on such and such a প্রথমে ছিল না? And she was examined by a doctor on such and such. Where is that evidence?
Doctor's evidence, my lord, at page number 35.
35. And she was examined on 15/1/2007. According to him, no violent marks or mark anywhere of the body of the person was examined. No spermatozoa was seen in the semen supplied. And also opined that it could not be ascertained whether she was raped or not. It is a settled proposition of law that conviction under section 376 of IPC can be founded on the sole testimony of the prosecutrix unless there are compelling reason for seeking corroboration. The testimony of a victim of sexual assault is vital unless there are compelling reasons which necessitates looking for corroboration of her statement, the court should find no difficulty in acting on the testimony of a victim of sexual assault alone to convict an accused, where her testimony, subject to the condition that her testimony inspires confidence and is found to be reliable. A trustworthy prosecutrix in a sexual offense case is a victim who provides consistent, credible, and reliable testimony about the crime, having a satisfaction upon the court that the accounts of events she has narrated is believable and not contradicted by other evidence. In such a case, such statement is a significant factor in determining the guilt or innocence of the accused. In the case in hand, as recorded herein above, it cannot be said that the statement of the prosecutrix was consistent. At one point of time, she stated that there has been a love affair between the accused, between her and the accused. They were living together. At the same time, she says that during that period, the living together and they had their sexual relation on promise to marry. At the same time, she deposed that she was taken to the road near END house near to the bamboo group near the END road and raped and was raped. In her 164 statement, she again deposed that there has been a relation and they had consensual sex on the pretext of getting married. However, in her testimony before the court, she narrated an altogether different story of forcefully picking her up by the accused from her residence to the bamboo grove and being and that she was raped therein. Such testimony, in the considered opinion of this court, could not have treated and such contradictions has also duly been brought to her by the defense during her cross-examination before the court. Therefore, in the aforesaid backdrop, this court cannot treat, the learned trial courts could not have treated the testimony of the prosecutrix consistent, credible, or reliable testimony. Even if we look to the corroboration that sought to have been projected by the prosecution, those corroborating witnesses, that is PW2 and PW3, also did not support the case of the prosecutrix. Such testimony further creates a doubt on the trustworthiness of the testimonies of the victim. In view of the aforesaid, in the considered opinion of this court, the determination made by the learned trial courts below are perverse. Such judgment has been passed, ignoring relevant material and relying on irrelevant materials. Accordingly, the present revision petition stands allowed by setting aside and quashing so and so. The petitioner is acquitted from the charges of so and so. Bail bond stands released. LCRB returned.
Highly obliged.
Yes, next case.
Then,
Yes, what is this?
Food Adulteration Act, Your Lordship.
Ah.
I was appointed as an
Amicus.
Your Lordship. I have done through the Your Lordship record right now, Your Lordship, but I have found, Your Lordship, that Your Lordship, there are two arguable points. Your Lordship. One on 13.2, Your Lordship, and secondly on the absence of independent witness while collecting the sample. Your Lordship.
Okay.
These are the 2 points, sir.
Today or some other day? When this we fix that other matter? Food adulteration?
16th, Your Lordship.
16th. We'll take up this on 16th. We can then our things will be easy. 16th. Yes, Mr. Bora. Long or short?
Very short, madam.
Acquittal or dismissal?
Your Lordship, madam, again the food adulteration matter. Regarding the service of the
No,
notice
13.2.
13.2, only one logically, only one C, only one exhibit. That will prove everything.
16th. We'll need your assistance on that day.
The one issue, and the
16 some other cases, because let me be frank,
Yes.
this food adulteration is something new for me. So I am also doing my own work, absolutely new things. So
regarding 13.2, my lord, only the, whether it has been served, duly served or not.
Not.
That is the issue. Whether it is issued.
if it is
Issuance-
not duly served, and that presumption will not come
Yes.
as saying registered post order. If not there, it will have 13 to right will be a valuable right, it will be vitiated, so everything will fall. That is your case.
That is my case, and here, my lord, regarding the service of the notice,
Mm.
they have exhibited the peon book, which is the photocopy. my lord.
Okay. Now tell me, okay, we'll see your case. Tell me, suppose there is no prescription of period during which it is to be served. But there is a prescription that he will have to file a representation or seeking hire to that central laboratories within 10 days of receipt. Suppose a report is furnished him after 2 years.
There's no use of that furnishing that report because he has to apply it immediately.
Immediately within 10 days.
Within
Now,
10
in one of the cases, he has been convicted saying that rightly, wrongly, you have received it. Within 10 days, you have not raised your grievance. So therefore,
That cannot be, my lord, because it has to be served within a period so that he can apply for the same.
but that is where, that should be a reasonable period. And what is a reasonable period? We'll have to because legislature in his wisdom has
No.
not said that this should be the
Because I
period.
expected that because of the 10 days has been
Okay,
given.
16th. Be here on 16th. We'll finish up these three cases. Your
Yes.
case, Mr. Kamal Agarwal's case, and Mr.
Bhatta's.
Bhatta's case. Similar point, or more or less the legal points will be same. Why should I dictate time and again? 13 will quote in the judgment. Facts will say facts will be different. 13 will get quote, and 13 to in Kamal Agarwal's case will have to give and what should be the reasonable time and why it's not there are some judgment. And your case, how it is to be proved by the prosecution that it has been duly served. In your case, the service is through
Peon
proof is through a Piron book, which is not or photocopy, and no secondary evidence for seeking was permission was taken. Maintenance there. How many matters are there? Call. We'll see.
Please, your lordship.
Yes.
Actually, your lordship.
Yes. What is the case?
Actually,
Hmm.
in the FIR, your lordship,
Hmm.
I was charged with theft case of, I'm a manager of accounts of State Bank of India, Pachala branch in those days.
Hmm.
And the customer, the account holder, one of the customer came down to the bank. He came to draw money from the ATM, but there was no money in as per the allegation in the FIR. So when he lodged a complaint, I came down from the stairs and grabbed him and assaulted him and took away 170 rupees from him. That is the allegation in the FIR, your lordship. So without any ground, any reason. So what happened, your lordship? After that, the police, Pachala PS from police, they came. They took me in a Maruti van, not official vehicle, Maruti van, and they put me 200 meters away from the bank. They made me stand there there was a choke there. So they made me stand, and after that, they brought some media people also. And after that, that time police vehicle came and they took me in the police station, and they threatened me to withdraw the case of the private respondent, which is the Havildar of the saying so. The ground was it was a setup FIR, FIR. It's a vengeful act.
So subsequent FIR, that FIR was lodged by the customer on 29/11/2011.
Yes.
And when have you lodged this complaint?
The customer is the informant here. I am the accused in the FIR, and but subsequently a charge sheet was made, your lordship. In the FIR, your lordship. The FIR is registered as 341, 325.
379 and 506, Your Lordship. But in the charge sheet, the relevant portion, Your Lordship, I'll read the page number 19, Your Lordship. Relevant portion is page number 28, Your Lordship, of the charge sheet. 325 and 379 is removed, which was the subject matter of the FIR actually. That one is removed, and 341 wrongful restraint and 506, which is criminal intimidation. That was
Where is his statement?
28 in page number 28 of the charge sheet, Your Lordship. Page number 28.
No, any statement of this victim? 161 statement,
No, nothing.
part of it?
No, no
Anything
statements
is there?
taken
Huh?
against me also when I was
Huh?
arrested also. No statement.
No,
was-
I'm not saying about this statement of this
No, it's not-
informant under section 161.
no,
Any LCR, anything is there, Muslim?
It is there, madam.
How do you know that?
161 statement. Victim of.
Searches under?
now, in the charge sheet, it was after reduction, it came to 341 and 506, Your Lordship. Criminal intimidation, wrongful restraint. Away from the subject matter of the FIR.
FIR to police.
FIR is kept here, sir.
What is the name of the informant?
Name of the informant is Pradeep Kumar Das, Your Lordship. Here in this one, the criminal petition, respondent number 3, Your Lordship. We had filed a defamation case against that person who came to arrest me on behalf of the bank, actually.
What is the offense? Search?
The charge is 341, and the charge sheet is 341 and 506 only. Wrongful
What is
restraint.
341 and 506?
Yeah, 506 is criminal intimidation, Your Lordship. Away from the main contents of the FIR.
341. And 506.
Yes, Your Lordship. Criminal means of, because 325.
Heard, Mr. Learned counsel for Learned counsel for the petitioner. You are Mr. Rabha
My name is A. Narzari.
Narjari. A. Narjari, learned counsel for the petitioner. Also heard Mr. Borthakar. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashing of FIR registered as Patasar Kusi PS police station case number 274/2011 under section 341/325+379 406 IPC and subsequent search sheet number 150 dated 7/12/2011 under section 341/506 IPC. The brief case narrated in the FIR is to the effect that the informant is a customer, the informant is a customer of State Bank of India, Patsala branch, and while he was returning home after lodging a complaint to the bank authority about unavailability of money in the ATM counter located in the ground floor of the State Bank of India Patsala branch at North Potti, PATTI, Patsala. The accused, who is a bank official, came down the stairs and obstructed him and caught hold of his collar of the shirt and then assaulted him. Full stop. And an amount of rupees 170 was also taken out from his pocket. During the investigation, this person's statement was also recorded. From the statement of the informant recorded under section 161 CRPC, what is seen is that there was a altercation between the accused and the informant as regards unavailability of money in the ATM. Unavailability of in the money of ATM. From the materials collected by the investigating authority, including the statement of other persons who were present at the place of occurrence, this court finds no material whatsoever to suggest any wrongful restraint of the accused by the informant by the accused bank of wrongful restraint of the informant by the accused bank official, except some altercation as regards unavailability of money in the ATM machine placed at the ground floor of the bank and a complaint made by the accused in this regard. After perusal of the material, including the statement of the witnesses, this court has also not found any material to suggest any criminal intimidation in as much as a criminal intimidation in as much as all altercation that took place cannot be given a color of a criminal intimidation. In view of the aforesaid, this court is of the opinion that no case under section 341/506 IPC is made out from during the course of investigation. Therefore, the charge sheet is based on no material. Accordingly, impugn proceeding corresponding to GR case number.
Case number. Here is Padasarguti PS case number is. there.
Patasargusi
Into
PS case
74
number so and so and all consequence proceeding pending before charge sheet is filed.
Learned Court.
Charge sheet is filed before.
SDGM,
Accordingly, so forget about it. Accordingly, the FIR as so and so and the charge sheet so and so stands set aside and passed, and petitioner is discharged.
Highly obliged, Your Lordship.
Yes.
Get the also.
Yes.
No, I am coming for a postment of proceeding. In a case, my lord, filed by the opposite party that initially resulted in final report, my lord.
Then.
Then, my lord, she filed objection against it,
Mm.
and thereafter, my lord, the court held that final report your lordship will find at page 24. Actually, my lord, it was a scuffle, my lord. In fact, my information is earlier to be won by the opposite party.
What is the final report?
Finally, page 24. Lecture 3. The findings is at the bottom, my lord, the evidences. So collected, it is known that there was a quarrel between both the parties regarding a plot of land. During investigation, it has been known that local people assaulted the informant, thereby caused simple injury and handed over. No evidence found against the accused person.
What is the magistrate's order?
Then the magistrate filed this, that is at page 44. Apparently, my lord, without consulting the medical report or anything, my lord. Page 44, my lord. 10-11-2017. Complainant is present. Filed a petition by so and submitted the.
Where?
Page 44.
Page 44.
Complainant is present and filed a petition by and submitted the medical documents which are present in another case record. In their case also, and also submitted some documents which are in custody of the superintendent of North Lakhimpur Jail. The documents are kept with the case record. Heard the learned counsel. Today the case fixed for the order. On perusal of the statement of the complainant and her witnesses and on perusal of the medical documents, it's seen that there is prima facie material against the accused person, Naniyarathi Chandra so and so, 448, 326, 354, 376, 511, man. Well, the medical report may kindly be seen, man. There is an affidavit in a filed by the opposite party. They have annexed them.
Yeah, anything, any record, case diary, something?
Records were confirmed, man.
Thakur, look into this case, whether any case is made out. Police has wrongly filed affidavit, final report, or magistrate was justified on the availability of the method.
My humble submission is that at least, my lord, 354, 376 are not there. At best, 320, maybe it was a scuffle, my lord.
So,
There was
taken under, cognizance taken under
Under, my lord,
326.
no, 448, 326, 354, 376, 511, my lord.
376.
Indicators are not there, my lord. Medical
Thakur,
report-
But other ingredients are there.
Medical report-
Thakur, go through it. This is a fight between them. Be the amicus corpus. Go through it and mark it. Everything is there. Now, what is the stage now?
No, there is an interim order, my lord.
Interim order. That is being stayed. Thakur, look into this. This is 2000. We'll take up it in January. After Bihu. After Bihu, all you can also go through it. If you can highlight that no case is made out and this
We
case.
can.
Yes, you can go through all of you. Okay. The matter stands adjourned to enable the learned counsel for the parties to go through the scanned copies of the record for a proper assistance of this court. Full stop. List this matter on 22nd of January 2024. Interim order pass earlier shall continue.
Much obliged, my lord.
Yes, what happened to Bhogiram?
Some name is shown in the cause list, let's say, correspondent number 2.
Whose name? Your name.
I am in.
You are the legal aid.
Lordship. And in other case,
Uh,
your lordship directed to be listed together with.
Together.
case-
These are two matters, isn't it?
Two meters on the same facts,
2015 meter.
15 meter is part of this year. 18
Now,
meter.
what is under challenge?
In 2015, my lord, we have challenged the, my lord,
FIR.
not the FIR, my lord, the Naraji petition which has been accepted and cognizance has been taken on the basis.
Okay,
of
that
the
is under
Naraji
challenge.
petition.
And second is,
Subsequently, my lord, they have come with another CR case
Hmm.
that we have challenged in the second petition.
so meaning thereby,
And
on the same facts, already a trial has commenced after rejecting the Naraji. Cognizance is taken. Isn't it?
Lord,
And
What?
subsequently, they file as a criminal complaint on the same facts.
in between, they have filed another complaint.
Ah.
That has been, in that case, my lord, we are discharged.
On the same facts.
Same facts.
Is it part of record?
Part of it.
Okay, we'll come back at 2. Yes.
Well, maybe on some other.
Why?
Well, the reason is I have from Arsenal, my daughter is suffering from fever, my.
Okay, okay, then okay, fine. Which year? 2015 and 18. Okay, keep that as January. Nobody will be interested next week doing arguing long methods. So let us not pressurize the lawyers. Yes. Twenty-fourth of January.
Watch.
On joint prayer, huh? The prayer of Lanes County for petition. 19. Yes, Munir, what is this?
Petitioner, he is one of the directors of a construction.
Ah.
Filed the FIR, he purchased a flat.
Ah.
There was some civil dispute with regard to the flat. One other person had also entered into an agreement to sell. Thereafter, he filed a title suit for specific performance of the contract.
Hmm.
It was awarded in his favor, the third person.
Inform in that person.
That
Okay.
person.
Okay.
Then execution was filed, He filed an objection to the,
Execution.
and that Miss case was on non-prosecution.
Ah.
Thereafter, again, she filed for restoration. Then in the restoration, the writ was kept in abeyance. The third person, approached High Court in a CRP.
Hmm.
And that was dismissed.
Now
Thereafter-
execution is it is being fought in the execution whether she was a necessary party or not.
Yes. Thereafter, she, order was passed in the title suit, the company, where the petitioner is one of the board of directors. They also filed application for restoration of the possession to the respondent number 2.
Okay.
That was dismissed.
Hmm.
Thereafter, against that order, the respondent number 2 preferred CRP before the High Court.
Hmm.
High Court said that there is appeal provision, you go and file appeal.
Hmm.
She doesn't file appeal. She approaches the National Dispute Commission.
Hmm.
The National Dispute Commission says that jurisdiction lies with the district forum. You approach district forum. Does not approach district forum, comes and file an FIR before the dispute police state, BIO. That is not under challenge in this.
So she files a complaint before the BIO, registered as a FIR.
It's FIR.
Then
in Sasir was filed in the BIO case.
Hmm.
He approached this honorable court, that was stayed.
Hmm.
Subsequently, she filed this FIR.
Hmm.
The same.
now we have come before this.
Yes.
Now what about the BIO case?
That is pending before this.
What is the number?
2 cases were there, my lord. One, we have challenged the FIR, we did not get the stay. After
Then Sasir.
criminal petition 422 of 2017 and criminal petition
List this matter along with criminal petition number
422 of 2017
422/2017 and
criminal petition 783 2017.
783 2017 on.
Up to your lordship.
No, give a date. Not this year, next year. We'll decide everything
After big
after Bihu. 27th.
Your lordship.
Yes, any longest, short, long hearing, tell us.
145 proceeding, Lordship. Initially, it was in my favor. It was ex parte order, Lordship. Thereafter, Lordship, in revision, that was set aside. Against that, I have preferred this revision petition, Lordship. There is stay order also, Lordship. So may I please take up the matter in the month of January, Lordship? Perhaps some civil suit is pending.
Definitely, nothing will be there as on date.
So in the month of January, in the meantime, I will take instruction from my client, Lordship.
But this is a 2012.
I'll also have to take instruction, madam.
To obtain instruction or otherwise, we will say that we'll as on date, we will not interfere with all this. But whatever decision is taken by the trial court
Yes.
and this court will be subject to any civil dispute that may be raised by any of the parties. That's all.
Madam.
This will be the order.
Yes, that's, there was no way.
Or should we dictate this order today itself?
Try once.
The learned counsel for the parties jointly submits that they require instruction from their clients in as much as the challenge made is to a proceeding under section 145 CRPC and the order date backs to the year 2012. Prayer stands allowed. Please this matter. 27. Yes, what is this?
Criminal revision.
Hmm.
Again, conviction under section 3 of the Railway Property Unlawful Possession Act 1966, by which the petitioner was convicted and sentenced for a fine of rupees 3,000 only in default simple.
Here in this case, my lord, in the cause list, PP Assam has been short. The name of Railway Standing Council not shown, my lord, in the cause list.
Yes, what do you want to say?
Otherwise,
What is the perversity?
but the main ground here, my lord,
Registry to list this matter on next week.
my lord, may be
No,
taken.
no, we'll at least railway should put to notice, na?
Yes.
We'll take up, maybe we may adjourn on that. List this matter again on 17, 18, 19th of December 2025 by reflective name of Special Council Railway, Special Council Railways. Also, whatever you intimate somebody.
Yes, yes. I will
There may be
intimate.
this Union
Yes,
Council.
I will intimate.
Yes. You also intimate that we are fixing it, Railway Council. Yes, Deka. Any, or you were in amicus in this case?
Not be able to conclude if we start, madam. Already 1 o'clock.
No, that's what we are asking is,
If
what is,
lordship takes up, I'm ready.
you are ready?
I'm ready.
What is your opinion?
There is something, madam.
There is something.
There is something.
Okay.
Because PW, there is a dispute with regard to the place of occurrence.
Hmm.
PW one says that the place of occurrence is in the paddy field.
Hmm.
Others say it is in the road.
Hmm.
And all are related.
Hmm.
PW one is the cousin of PW two.
What is the sentence?
Sentence is maximum is 3 months.
Okay, we'll come back.
And-
How many meters left? This meter
is
will
the
be
last.
fixed. Or today?
Today.
Until ultimately you are amicus, so you'll have to give, you might have some other
No,
cases
I don't have any other matter.
at 2, therefore.
I don't have
okay.
any other matter.
If you have no problem, we'll come back. Yes. Or Thakur?